Thanks everyone for joining this episode of our webinar series on best practices in eDiscovery. Today's session is focused on the massive shift in the ESI landscape and the explosive emergence of non-email communications in eDiscovery, with a lot of this driven by the COVID pandemic. My name is Jeff Fugit. I'm the Chief Revenue Officer for Lexby, and I'll be the moderator for today's event. Our webinars take place monthly and cover a variety of relevant eDiscovery topics, trends, strategies, as well as best practices. Space is limited to the capacity of our webinar platform, and several of our events of late have been very popular. So I recommend registering promptly for those sessions that are of interest to you. If you have any technical issues or questions, please email us at webinars@lexby, and we'll address those right away. Our webinars are available online at lexby.com for viewing via streaming video or downloadable as PDF presentations or an MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexby.com. To be notified of future live and on-demand events, please email us at webinars@lexby.com or follow us on LinkedIn. Based in Austin, Texas, we provide the industry's most affordable cloud-based eDiscovery software and services. We specialize in equipping organizations with an eDiscovery solution that gives them full control over the eDiscovery process, comprehensive DIY capabilities, and incredibly fast performance. We're designated as the industry's most affordable and full-featured DIY eDiscovery platform. We provide the industry's fastest eDiscovery processing and document review capabilities. We deliver the industry's fastest return on investment, as noted in a recent study by G2 Crowd. And we've got an experienced eDiscovery staff and expert consultants who are all ACED certified and are ready to assist on a moment's notice. If you'd like a demonstration of our platform, simply email us at sales@lexby.com and we'll get that scheduled for you. Our guest speaker today is Gene Albert. Gene is the CEO of Lexby. He's a sought-after speaker on eDiscovery technology issues, as well as legal tech. He's also on the planning committee, Electronic Discovery Institute at the State Bar of Texas, and he is an eDiscovery consultant and expert. Gene has an BA and MBA from the University of Texas and a JD from SMU. Before I turn it over to Gene, I'm going to touch on the drivers behind today's topic and ask for your participation in some polling questions to help set the stage for Gene. Last year we had Robert Keeling, a partner at Sidley Austin, present on a session about the mobile-first custodian. And during that session, we learned about smartphones and the app economy and how they're big catalysts for the shift in the ESI landscape. We might need to revisit that session later this year, given the impact of COVID on that shift and the continued utilization of smartphones and mobile devices. In the US alone, there are 396 million mobile devices. So that equates to approximately 1.2 connected devices for every person. And with data traffic surpassing 13.7 million megabytes, there's a lot of evidence in that data. If you want to access Robert's webinar, simply email us at webinars@lexby.com and we'll send you a link to that recorded session. One of the really critical drivers in the shift in communications is the convenience of using instant messaging apps over email. Millennials fully embrace these new communication options and actually prefer instant messaging over email by a significant margin. Enterprises also want instant dialogue with mobile connected employees in order to gain a competitive advantage and pushing that data out to the far reaches of the enterprise. As a result, the top 4 messaging apps have more than 4 billion monthly active users. So as you can see on this slide, you've got Zoom, LinkedIn, Citrix, Apple iChat, Skype, SMS, Slack, WhatsApp, Android Messenger, Twitter, Facebook Messenger, Google Hangouts, iMessage, and this just barely scratches the surface. So there are hundreds of apps that have messaging capabilities. Zoom in particular, as you've probably seen, has recently become a verb and has been heavily promoted in the media as the communication and collaboration platform of choice during the COVID pandemic. We're going to talk a little bit about Zoom's growth here in a minute, but when you're thinking about your case and your matter and interviewing the custodians, it's really critical to keep these in mind and understand what this landscape looks like, what they utilize. It's very beneficial to use a data map to understand what messaging platforms and what forms of communication are utilized by the custodians. And while I really talked about the growth in instant messaging and collaboration apps, as you can see on this slide, email still has staggering quantities. It is fully ubiquitous. There are over 300 billion emails sent daily, and there's a lot of evidence in those emails. With that said, the average custodian has 1.9 email accounts, and so it's important to know how those email accounts are utilized. Are those personal? Are they business? Do all email accounts, are they enabled on their mobile device? Do they port data back and forth across those accounts? All of that's important to understand. So here's a breakdown by application. So when you see the COVID pandemic hit, you see strong growth across all these apps. However, the top three, Cisco AnyConnect, the Palo Alto Networks app, as well as Zoom, really show explosive growth. If you're not familiar with these platforms, it's very important to become familiar with them because they are critical sources, or can be critical sources of evidence. A lot of employees feel less hindered in communicating across some of these platforms, and so they tend to be less formal, and they're often excellent sources of evidence. And as I mentioned on this slide, these are various applications and the corresponding file types. I'm going to talk about that a little bit, but this chart shows the growth of these apps in March over February of this year. So again, the impact of COVID has driven just staggering growth for a lot of these organizations. Zoom in particular, as I mentioned, now has become a verb and is often featured in the media. So with that said, Zoom, Palo Alto, Cisco, Citrix, Proofpoint, RingCentral, all of these have different capabilities, and not all of them are messaging. Like LinkedIn Learning isn't messaging specifically in and of itself, but LinkedIn does have a messaging capability, as do most social media platforms. All of them tend to export data in different formats and different file types. So you need to make sure that you're capable of gaining access to those, collecting them, reviewing them, and building out your case. And with LexB, you're able to work with these file types. So it's really important to understand which applications are utilized by your custodians. It's important to know the quality and character of the custodians you're dealing with to ensure you're able to identify the apps and tools that are being utilized. Zoom in particular, once the COVID hit, has seen growth from over 20 million sessions a day to more than 300 million sessions a day, which is just staggering growth and a staggering amount of data. So if you rely heavily on email previously and today, it's important that you pay attention to Gene's presentation, because evidentiary ESI has now been scattered across a multitude of existing and emerging communication channels. And because of COVID, that's only accelerating faster. So you're going to see further fragmentation. You're going to see the mix of communication channels expanding dramatically. And that's going to have a big impact on your cases. Now we've got a couple of polling questions we'd like to ask your assistance in answering to help set the stage for Gene. What percentage of your cases in 2019 involve collecting non-email messaging in the discovery process? 0 to 10%, 11 to 25%, 26% to 50%, or more than 50%? And while you're answering that, and I'll thank you for participating in our polling questions today. All right, I'll go ahead and close that poll. And then our next polling question: how many document-intensive matters do you handle each year? 1 to 5, 6 to 10, 11 to 25, 26 to 50, or 50 plus? We're seeing a lot of growth in document-intensive matters. I know a lot of our clients are now dealing with hundreds of thousands to millions of documents for a bunch of their matters. So we're definitely seeing a growth in document-intensive cases. It'll be interesting to see, how the audience answers this and how that correlates to what we're seeing in the market. All right, I'll go ahead and close that polling question. And without further ado, I'll turn it over to Gene Albert. Gene?
Thank you, Jeff, for that introduction. And thank you, everybody, for attending this session of the LXP eDiscovery webinar series. This is a really important one that I've been wanting to do for a while. You see the agenda here, what we'll cover in eDiscovery, non-email messaging, electronically stored information, ESI, as litigation evidence. Some of the problems that can come up with is how we can solve them, and then how that operates in a litigation workflow. A few initial comments. One is I can talk fast sometimes, and there's a lot of material to cover here. We do make these available as PDF later and as on-demand video and MP3 audio. So you'll get that after the webinar, and we'll have it up on the website. Also, my examples are from our software, the LXP eDiscovery platform. We keep these webinars very educational, and I know our software best, but the general issues, problems, and solutions that one could address with integrated email messaging, non-email messaging, would go across from other platforms that work with non-email communications. We'll have a survey at the end. Please take a minute and complete that if you can. We take those very seriously and read all the comments and respond to any that should be responded to. And we definitely use those for new topics and how we modify this program in the future. So thanks again for attending and for your comments if you have them, and we'll get started. This slide shows just the common texting and messaging services that are out there now. And I think they generally go into three different types. First is a text messaging used on the phones and now smartphones, also known as SMS, which is a simple messaging service. And these are pretty ubiquitous on Android and smartphones, as well as other phones that people are using. The second is corporate messaging apps. They're Skype and Google Hangouts are very well known and used in companies. Slack has been growing a lot, but it can also be used in LinkedIn and other and sometimes proprietary corporate messaging services used by companies, particularly regulated industries where they may be requirements on keeping all the messaging in certain formats for a later regulatory review. And then there's a lot of consumer messaging services, and these have been the fastest growing recently and worldwide, and some of them perhaps supplanting texting and SMS, particularly in parts of the world where that's expensive or cost prohibitive, having the text messaging, and the internet messaging is less expensive. Go through some statistics of the growth in this area. First, despite some rumors to the contrary, I think email messaging remains very, very ubiquitous. So even though we may be using email messaging less than we did a few years ago, and have relied on some of these text messaging, some of these other services, the people that use email messaging remains very steady and continues to grow, if not at a real high rate. The next one shows SMS text messaging. This also continues to grow. The users that are using text messaging, and at a faster rate than the email messaging, but not near what some of these other services are. But text messaging is still being used very consistently, which is probably no news to anybody. This slide's interesting. That this shows that even though the users of text messaging and is continuing to grow somewhat, the actual messaging sent is declining, supposedly. My supposedly there is these are worldwide statistics, and I haven't seen anything of if that's true in the U.S. or if that's more of a worldwide phenomena, but I think it probably is happening in the U.S. as well, certainly. And this is showing also the very fast growth of the consumer internet messaging services like WhatsApp. That's really growing at an exponential rate. And WhatsApp was recently bought by, or a few years ago by Facebook, and was blended into their texting or messaging service. So these have become very popular now. Question is, how much does this really matter in litigation? I think the answer is that it matters a lot, and it's going to be mattering more and more for a couple reasons. One is certain types of litigation, the messaging may become very important just from the type. And then I'm thinking of employment law cases where it's so that in social media often is important as part of the litigation. But even in standard commercial litigation, we're seeing more and more that the participants that have evidence are relying less on email messaging and more on their phone for texting, a corporate service like Skype or Google Hangouts used in the corporate environment, or even they're blending over and using consumer IM messaging applications like WhatsApp. And that's a question to ask in the litigation, or does any particular custodian or the participants in general, are they, what are they using for their messaging, and are they using these services? So whatever the truth of that is today, I think it is being used. It's moving in that direction. So we're going to see more and more of this in the cases going forward. And this seems to me similar in many ways to what we saw when email was first becoming popular, that many lawyers, out of maybe ignorance, just didn't ask about email and didn't use it in their cases. And it became more and more important. And right, a lot of lawyers missed a lot of evidence in cases simply because they were unfamiliar with how to go about getting that evidence in cases. That isn't true anymore, or not very much, but I think that is true for these newer type of communications technologies, hence the reason for this webinar. This slide is interesting, and it shows, it's a little bit small, but it shows the sort of the life cycle of some of these services. So they can be very fatty and can come and go, as you can see from some of the earlier ones that are no longer being used anymore. The other thing that's interesting is you can see just the exponential growth of some of the consumer IM services, towards the, from 2012 on. And this slide goes through the data goes through 2016, but the other things I've seen show that just continues to skyrocket at an exponential rate for usage of these services. So this is, coming more and more, and I think we're just beginning to see this evidence will become important and roll into litigations that are being filed in current. So what's the problem? Well, I think there's a lot of problems with it that people run into with this, and they're running into problems on properly collecting and utilizing this non-email messaging or ESI or communications. And it has been and remains difficult. Why? Well, they're difficult to collect from their sources often. Text, I think we've gotten more used to collecting text messaging, which generally needs to go through a forensic provider to get the text messaging off of the phone, the smartphone or the phone. Sometimes can be available from subpoena. But the other ones are new. Some of them are fairly easy to collect from. Some of them are very, very difficult to collect from and require forensic collection as well. The export files, when they come out, are non-standard, and they're not unitized, so they'll often be in one big document, which makes it very difficult to work with on a variety of things that must be converted into reviewable form and unitized to really be usable in the same way we're used to with email and other documents. There's a question of who collects. Depending on the source and the case, these can be collected by forensic service providers, as I mentioned. eDiscovery companies like our own can collect these sometimes. The IT people in departments, in the IT departments in companies and organizations involved in litigation sometimes can collect these. And some of these sources can be collected by the custodian directly if it's appropriate for that case. So there's quite a variety of what can be done, and that this can be confusing. As I mentioned already, they're often not unitized, and they're in one mega file, which is a problem. The results from all this is that it just is very difficult to bait stamp print, uses exhibits, do privilege review, do attorney's eyes only, responsive review, privilege review, et cetera, et cetera. And as a result of this, sometimes important evidence is missed, both on your side, or you failed to effectively ask for it from the other side when it could have been important or even case determinative. So the rest of the webinar will go through and show methods of addressing these issues effectively in a litigation. What would you want to do this correctly? At Lexby, we call this integrated eDiscovery messaging, and it's using combination of technologies to be able to make these messaging, non-email messaging communications look like an email in the litigation review platform and in the litigation life cycle. And we found that this has been the most satisfactory for clients. So the technology is converting raw messaging data into discrete reviewable emails or PDFs that look and act like an email, complete with metadata extraction, and then getting all that information into the review platform, so it can be used by the attorneys and others on the review team. This is going to include exporting and collecting the data, processing it into usable text and a review format like PDF, getting the metadata extracted and into load files that can be brought into the review platform, and then bringing it into the platform for review, search, and production. This is another take on the workflow, and I'll go through some of this in more detail, but it takes through the various steps that one would want to think about doing in setup and planning, collection, processing and upload, review, production, and getting ready for depots, motions, and trial, and the different sub steps in the workflow that one would want to be doing. This slide shows custodian identification and data mapping. I don't think this is done that much by people, but it would be good to be doing it more, and I think it's going to be increasingly going to be important. The idea here is that first one identifies the custodians, and this can be your custodians and also opposing parties, and then putting together a data map. For one's own custodians, this can be done in conjunction with custodian reviews, custodian interviews, and the idea is that you put together in a coherent, consolidated report all the different data sources or data repositories that a particular custodian would have. What are the types, and how much data is there, and how much in general. So this is an example of one where the custodian has a LinkedIn account, Google Hangouts, Facebook, text, email, Twitter. There are issues in the particular case on many of those if discoverable ESI is in these different repositories, but in our experience, it's not at all uncommon for personnel in a corporate or organizational environment to be using their text messaging and sometimes some of these other even consumer or personal communication technologies that has discoverable evidence that is relevant to the litigation. Many people aren't that good at not using their personal devices and data sources for company work. Other companies, they do that well or very well. So it's just a matter of asking and finding out in the particular litigation. And these data repositories or data sources part of this data map are in addition to the other ones that you would expect, and that would be somebody's workstation at work, their laptop, their business phone, but if they would have cloud computing, cloud resources for email or documents, corporate shares, et cetera, all this would go into the data map. This slide shows an example of the normalization that needs to be done in LinkedIn. So once LinkedIn messages are brought out, they in some ways look like an email, but they're in a CVS, which is a text delimited file, comma separated values that can be converted into Excel type file, and then that in turn would be used for generating a reviewable PDF and also having metadata that would go in with a load file into the review tool. So below is after some normalization into an Excel format. And then this next slide here shows what it looks like when it goes into the review platform. So you'll see that a PDF has been created of the text message, the LinkedIn and chat message that looks a lot like an email. It says the type, but it's got sender, receiver, date, time, sent, received in the message. So this is what everybody wants to be able to work with this on a unitized basis like an email message. You can see on the right is where the metadata is showing that's associated with it. So the date, sender, receiver, et cetera, shows there for this LinkedIn message, and that can be used for production and also for privilege review and privilege coding. This next slide shows similar raw data coming out of Google Hangouts. And similarly, the normalization into an Excel that can be used for getting it into the review tool. And then also what this looks like once it goes into the review tool. The PDF there now in the review tool is now showing that it's the Google chat. It's got all the other associated information with it. One more, this shows what raw Facebook data looks like coming out of Facebook collection and then for messaging, and then what it looks like when it's normalized again. So these all been normalized into the same format for pre-processing. And this one slide shows what the Facebook message looks like once it goes into the eDiscovery platform. This next slide is the integrated browse view. This is a table and is very important because it allows all of the communications, whether it's email or these non-email communications, to be put into a single reviewable table that you can filter and sort on. The fields there are showing a date, who from, type. Of course, all the other fields built in and custom fields in the eDiscovery platform could also be shown here. But this allows it to go into date and time sort, and that's very important because it's very common for fact witnesses in a case to move between different types of communications within one conversation. So somebody might start off in email, and they might switch because they go out of the office or for other reasons into text messagings or into their chat, their corporate chat, or whatever. So it's amazing how they go back and forth, and to get a real feel of what the conversation was and how it resolved, you need to get those all in one place and be able to look at them. And then in one table like this, then now you can do your you can filter by sender, receiver, date range, document type, whatever needed. Other custom fields have been created, and then you can open up the documents by clicking on the link on the left, so you can see what the actual document look like, and it's been converted into a PDF, so it's reviewable. Here's similar with the search results. So here the search has been on Tallahassee, and you can see that results are coming back, hits are coming back both from from different sources, so that you can have chats and different messaging from technologies, email, documents, etc., all coming back in one integrated search. And that's very important to make sure when you do your search terms that you're getting all the documents no matter what technology they're in. Here's an example of once the documents opened up from search, it's showing the highlighted hits off of that same search term, and that ties back into the PDF view of the document itself. So we're seeing two different views of the same document, one from the hits tab and the other one from the PDF review tab. Very important in all this is privilege review. So now that the non-email communications have been normalized into a PDF format and are in the review platform, you can now do a standard privilege review and also do tagging for work product, attorney's eyes only, confidential, et cetera, et cetera. And can have the logic of the eDiscovery platform on suppressing that or whatever else is done for the particular document, roll through in the same way that you'd have with email messages. Similar issue with redactions. You may want to redact certain information here. Some confidential number is being redacted, so the review platform can create a redacted view of it, and that can be worked with in the same as one would with emails or with other documents in the case. Similar issue with the annotations. Annotations are used for taking a document and getting it ready for depositions or testimony at trial, and allows the examining attorney to have a version of the same document with notes added to remind him or her about questions to ask, et cetera, et cetera. And this can now be done with chat and other IMs and other similar messages in the similar fashion we do with emails or other documents. And very important also is to be able to produce a bait stamp copy of it. So now that it's in a PDF format, you can have a bait stamp copy of it for production and depositions in similar fashion as you would anywhere else. A similar issue with getting these ready for exhibit for introduction at trial. Here's an export of the privilege log, the metadata that we were talking about earlier that's brought in from the instant messaging metadata is now used to drive the date, time, subject, et cetera, of the privilege log, and that can be brought out in a similar fashion to however else one would be doing a privilege log with other documents in the case. This shows also that these documents being unitized can now be linked into facts and issues in the case chronology portion of your eDiscovery review tool, so that you can build up your facts and issues timelines, integrate it in with deposition and transcript evidence, and build out the case to see if one is ready for summary judgment and other motion practice, and for being able to prove out one's jury instructions if it goes to trial. That is the kind of a brief overview of how this works, and let me do a summary and recap now. So texting IMs and other messagings are growing in use. They're increasingly important. They certainly raise a lot of problems in collecting, processing, reviewing, etc. But these things can be solved, and this should all be integrated into one standard eDiscovery workflow. And then last, to end this, we've got a checklist of things to consider in non-email communications, electronically stored information. One is determine the importance of it. Is the ESI communication likely to be important in this case? Then one needs to spend more time to make sure this is all done well. But I think while some case types it's almost always important, increasingly in all cases this is going to need to be checked and determined if evidence is important. That would be in these communication repositories. Begin planning early. Evidence can be waived or lost if not pursued consistently and diligently. The courts, in giving you the rights to get this type of information, don't want to see that you thought of this late in the case, and it's very easy to waive this if you haven't properly got this into your all of your pleadings and your other court communications that you've been asking for this consistently. Next one should early on identify one's own custodians, do your custodian interviews, and as part of that find out what communications technologies and repositories there are, so you can be looking at those. So you can interview your adverse custodians, but you can find this out through Rule 26 and other methods. So do something similar for adverse custodians and find out what they know, and same issue for third-party custodians for subpoena, et cetera, and they can often be approached more directly. Next, ID all the non-email communication technologies used, what's used as part of companies or organizations as part of their culture, or a corporate mandated app. What do the individual custodians do? Everybody's got different habits as to what email and non-email communications technologies they use, and find out from your custodians and witnesses, and make sure you've identified those technologies, and then you can now track those out to other custodians who they've been in communication with. Make your hold requests specific, your hold letters to your own custodians, and then also to your adverse party and third parties. If you send those out, make sure they're very specific as to the non-email communication technologies, and that you're to be able to make sure that they're not being deleted, or to preserve your rights if they are, for sanctions. Do data mapping of your custodians and others to determine what technology they're using or repositories they have. Your request for production of documents should also be specifically and should be specific and specifically address non-email communications evidence. Your review tools and vendors should be competent for this, to where it can bring in the information, and your vendor should know how to bring this information in to make sure that you're able to effectively collect, convert, and utilize it in your eDiscovery review tool. If you're using, if you have an ESI order protocol, which is a good idea to do in any type of case that is any kind of complex issues with electronically stored information, that should specifically address collection, production, et cetera, of in the format of non-email communications. As you have your Rule 26 meet and confers, or similar things under state law matters or formal communications, be consistent asking about these communication technologies and track them down, and make sure you know what those are being used by adverse parties, so that you can properly run down this information and make sure you receive it. Look for holes in the incoming productions. If you've done this other work previously, you know what to look for. Once the productions come in, they should be analyzed to see, are you seeing consistent information between individual custodians across all communications technologies. And if you know that a specific communication technology is being used by a custodian or cross custodians in the company are using consistent usage of that in the volume that you would expect in the production, or has something or other gaps and holes and has something been missed. This is where one can find out if all the information has been produced properly. And then if you do this type of analysis and show that you've been asking for the information and that it wasn't received, or it was received with gaps and holes, then the courts now are going to be open to give you further discovery rights and not treat it as a fishing expedition. Lastly, follow up in your depots. Ask your deponents about communication technologies and tie in with what you've done previously to make sure that you understand and you're getting all of the information that you thought you were supposed to be getting in your previous request in the production. Well, I think we're running out of time here. We've just gone a little bit over 30 minutes. I will turn it back over to Jeff. Thanks again for everybody attending. If you have any questions about this specifically, please let us know and we'll get back to you. And again, please take a minute and fill out or complete our survey after the end of this as well. Thank you again for attending. Bye. Back to you, Jeff. Thanks.
Thanks, Gene. That was a fascinating presentation. Now I'm going to briefly walk you through the LexB eDiscovery platform and capabilities. As you can see on this slide, LexB offers an end-to-end eDiscovery solution in the cloud. It's full-featured, it's DIY, it's infinitely scalable, and it's accessible with a browser. So you can access it from mobile devices like iPhones and Androids, although we really wouldn't recommend doing a large document review with a device that small, and actually would recommend having a large monitor to go through and review those documents. But it certainly is fully capable on devices that are smaller. One of the great aspects of the time that we live in is that there's absolutely no need to have large, expensive in-house technology infrastructure for eDiscovery. Broadband is almost ubiquitous, and the cloud not only delivers massive computing and storage capabilities for a fraction of the price, but it is also highly secure, and it's more secure than most law firm IT environments. But as you can see here, we offer advanced high-speed ESI processing. It's virtually infinitely scalable. It is incredibly fast. We have advanced high-speed databases. We've got AI-powered analytics and technology-assisted review. We've got a highly flexible document review workflow that you can customize to fit your exact needs. We've got incredibly powerful search capabilities. We have best-in-class security. You have a case timeline builder. You've got powerful administrative controls, as well as very easily managed productions. All of this enables you to equip a remote legal team with a very powerful solution so that they can continue to work during times like COVID, so that we can help you solve the challenges of non-email ESI sources and the continued fragmentation. We get you from document ingestion to document review faster than any other platform. And we enable your organization to fully embrace the power of the cloud in solving your needs. On this next slide, you'll see the LexB Uber index. So it's a multi-source concatenated singular index. So what does that mean? Well, first, we extract all the native characters out of the documents that are ingested into the platform, and those get included in the index. Then we create a normalized PDF simultaneously and OCR those, so those characters are included in the index. Then we do an OCR of all images, again simultaneously, and then translated characters are also included. All of those are included and fully concatenated in the index. So you've got one lightning fast single index. So searches come back faster and you can seamlessly add documents without re-indexing. Because of that, that means that you don't have to wait. I mean, I talked to a law firm just the other day, a larger plaintiff firm, and they said that their relativity reseller had an instance of relativity where if they wanted to add documents and they had to re-index, they were actually unable to access the case for 48 hours. And that's just not acceptable in today's day and age. So you really need a Uber index that enables you to always access the documents that you need. It's lightning fast, and it enables you to very quickly identify the evidence for your case. Next, you'll see the audio files transcribed in the LexB eDiscovery platform, and we've got a very advanced artificial intelligence transcription capability. So it's machine transcription. It automatically identifies and designates each speaker. It enables you to review the transcription files and quickly identify and tag where on the audio track the evidence resides. This is incredibly powerful and helpful in addressing the challenges of the non-email ESI, especially when you're having Zoom calls and you're having Skype calls, and a lot of those sessions are recorded. This can be incredibly useful in identifying evidence for your case with those types of files. Also included in the LexB eDiscovery platform are advanced applications of artificial intelligence. So within LexB, you've got cognitive image recognition. So if you load a photograph into the LexB eDiscovery platform, the AI algorithm will automatically identify the contents of that photo and categorize that, so you can very quickly search through photos. Say, for example, you are working on a construction defense matter and you want to search for photos of a crane. You can quickly do that with the cognitive image recognition capability within the LexB eDiscovery platform. We also have sentiment analysis, also driven by artificial intelligence. We've got language translation capabilities that are advanced and utilize a neural network that's very powerful, gives you better fluency, continues to learn and improve as it continues through the documents. So you get a very high quality translation, and that enables you to maintain control over the case and rely less on third parties. And then we also have the transcription capabilities that I've mentioned. At LexB, we also deliver the industry's best pricing. So this example is LexB versus a relativity reseller. This is one of our clients that had to get a bid and went to a relativity reseller to get a competitive bid. So in this case, the relativity reseller was going to charge them $125 per gig to process. At LexB, we don't charge for processing. That's included in your subscription. So that alone saved the customer over $30,000. In terms of user fees, the relativity reseller is going to charge $95 per user per month. LexB doesn't charge any user fees at all. For technology-assisted review, near duplication, email threading, those were included in the relativity analytics. All of that costs $30 per gig per month. With LexB, all of those are included with your subscription, so there's no charge for that. And for hosting, relativity was going to cost $8 per gig per month in this example, and LexB only costs $5 per gig per month. So that's the rate where our subscriptions start. We also have a flex plan, which is a month-to-month plan. But in this instance, we were able to save the customer over $40,000 just on a single case. As I mentioned, LexB has industry-leading security. We passed extensive application penetration tests by IBM last year. There are U.S. federal agencies and municipalities that utilize the LexB eDiscovery platform, and our AWS environment has multiple security certifications that we're happy to share with you should you need to review those. LexB also works with third-party analytics companies, so AP, Brainspace, NextLP, as well as additional capabilities at AWS. You're able to get a comprehensive view into the data that you're working with. So if you're in need of additional analytics, we do have partners that we work with. And with that, I'll go ahead and ask our last polling question, and that is, would you like a demonstration of the LexB eDiscovery platform? And while you're answering that, I'll let you know that we'll be making the following available to webinar attendees. You can access a recorded streaming version of today's session. You can get an MP3 podcast or a PDF. Please let us know if you have any questions or comments about this webinar or suggestion for future topics. At the end of today's session, you'll find a survey. Please fill that out. It's really important to us. We want to continue to improve on the webinars that we bring to you. And we take your feedback very seriously. This webinar is part of the LexB eDiscovery webinar series for notices of future live and on-demand webinars. Please email us at webinars@lexb.com or follow us on LinkedIn. And with that, I hope you stay healthy and out of harm's way and continue to be productive during the challenging time that we're faced with the COVID pandemic. Please let us know if we can be of assistance with any of your matters. Feel free to reach out to me directly participating in our polling questions today.